the U.S. presidency is going in another shift, and this time, it's shaking the foundations of corporate America. In Washington, new orders are being signed, investigations are quietly expanding, and boardrooms across the country are holding emergency meetings. Something big is happening behind those polished glass walls. A fundamental change in how the government views diversity, equality, and inclusion. For decades, these were the cornerstones of modern workplace culture. Now, overnight, they're becoming potential legal liabilities. What began as a movement to open doors is now being re-examined under a microscope held by the highest levels of power. Across the nation, a quiet tension is spreading. Human resources teams are rewriting policy manuals. CEOs are calling in lawyers. Programs once praised in press releases are suddenly being reviewed, paused, or erased. And at the center of it all is one growing question. Is this the end of corporate DEI as we know it? Or simply its next evolution? The current administration has made it clear. The era of unchecked diversity mandates is over. With a new approach to civil rights enforcement, the government is signaling that DEI programs which, in its view, cross into preferential treatment will face direct scrutiny. In the weeks following the inauguration, the Justice Department began taking its first concrete steps, sending requests for information to contractors and grant recipients. Inside government documents, a new phrase started appearing: the legal DEI discrimination. That wording alone sent shockwaves through the business world. For years, major corporations had operated under a completely different expectation. Inclusion goals, mentorship programs, and demographic tracking were not only permitted but encouraged. Now, the pendulum has swung in the opposite direction. The message coming from Washington is unmistakable. Every policy that treats people differently based on race, gender, or identity will be examined through the lens of federal law. Inside the Department of Justice, the newly launched Civil Rights Fraud Initiative has become the vehicle for this effort. Officials say it's designed to ensure that taxpayer dollars are used lawfully, without bias or favoritism. In practical terms, that means the government can investigate whether any organization receiving federal funds has violated civil rights statutes through its hiring or grant practices. That may sound procedural, but the implications are enormous. A tool called the Civil Investigative Demand, or CD, allows federal investigators to request detailed records, emails, and communications long before any lawsuit is filed. For companies that rely on government contracts, even receiving one of these demands is enough to trigger days of boardroom discussion and late-night phone calls. Compliance officers scramble to gather documents. Lawyers warn about exposure. Executives try to reassure investors. It's a process that can drag on for months and cost millions, even if no violation is ever proven. This shift became unmistakable when Harmeet Dillon, the Assistant Attorney General for Civil Rights, appeared before the Senate Judiciary Committee. Her message was blunt. She said that either DEI would end on its own, or the administration would bring enforcement actions to stop what it considers unlawful preferences. Supporters applauded the statement as restoring equal treatment under the law. Critics, however, saw it as a warning shot that could chill legitimate diversity efforts nationwide. Meanwhile, the Equal Employment Opportunity Commission, or EEOC, is also changing direction. With new leadership now confirmed, the agency has the votes to roll back previous guidance and set new priorities. Officials have stated that eliminating what they call illegal DEI will be one of those top priorities. That means companies could soon face more investigations into whether their internal diversity programs cross legal boundaries. This policy wave isn't limited to Washington. State governments are getting involved too. Attorneys general in several states have opened their own reviews into DEI programs, focusing on whether public contracts or hiring practices comply with state and federal laws. For example, large consulting and technology firms that manage state systems have received letters demanding details about their internal diversity policies. It's a coordinated pattern of scrutiny that corporate lawyers say they haven't seen in decades. Halfway through this unfolding story, one thing is clear. The rules of the game are being rewritten in real time. The very initiatives that were once celebrated as moral and social progress are now being examined as possible legal risks. Companies that once competed to outdo one another in public diversity statements are now quietly erasing them from websites. Training sessions once labeled as bias awareness are being renamed compliance programs. It's a linguistic shift that reflects a much deeper cultural transformation. If you value this kind of clear, balanced reporting, no spin, no shouting, just the facts and their real-world consequences, now's a great moment to support the channel. Hit subscribe, turn on notifications, and help this community keep growing. Your support lets us keep explaining complex stories that shape the world we all live in. Now, back to the bigger picture. At the center of the government's enforcement strategy is the False Claims Act, a powerful civil law that allows the government to recover money obtained through fraud or misrepresentation. It's been used for decades to prosecute everything from defense contractors to healthcare companies. Under this law, organizations found guilty of violating its provisions can face damages equal to triple the amount of the contract, plus additional penalties for each false claim. What makes it especially consequential is that it encourages whistleblowers, employees, or insiders to report misconduct and, if successful, receive a share of any recovered funds. For corporations, this creates a two-front challenge: external government oversight and internal vigilance. Even if a company believes its DEI program is lawful, the risk that a single disgruntled employee could trigger an investigation is enough to force sweeping changes. That's why experts say this new wave of enforcement is reshaping not just public messaging, but corporate behavior itself. Behind closed doors, executives are wrestling with difficult questions. How do you maintain a culture of inclusion without violating the letter of the law? How do you prove fairness in hiring while steering clear of quotas or metrics that could be misinterpreted? These questions don't have simple answers. They require companies to navigate between ethics, optics, and legality, three forces that don't always align. As the months go on, more information is surfacing about how the Justice Department intends to proceed. Officials have said that the goal is not to eliminate fairness initiatives entirely, but to ensure they comply with existing civil rights laws. Still, the tone of enforcement is far more aggressive than in previous years. For corporate leaders, it's a signal that the status quo has changed. Even local and state governments aren't exempt. The Justice Department has opened reviews of hiring and appointment practices in several agencies, including environmental departments and city administrations. The idea, according to federal officials, is consistency, applying the same standards across public and private sectors. For local officials, though, the effect is anxiety. Few want to become the first example of a federal civil rights case under this administration's new approach. Meanwhile, law firms across the country are updating clients daily. They warn that compliance now means more than simply avoiding overt discrimination. It means being prepared to justify every policy and training module. The very phrase diversity goal is being replaced with equal opportunity standard. The framing has changed, and with it, the way companies talk about fairness itself. But beyond the politics, there's a deeper human story. Employees who once saw DEI as a source of belonging may feel uncertain about what comes next. Those who felt excluded by identity-based initiatives may feel vindicated. Managers are left to navigate workplace conversations that are suddenly far more sensitive than before. It's a delicate balancing act between maintaining morale and ensuring compliance. In the months ahead, we can expect the enforcement trend to continue. More investigations will likely emerge. Some cases will settle quietly, and others may reach the courts, shaping precedent for years to come. Each ruling will help define what DEI means under the law and where the limits of government oversight lie. Observers predict that inclusion efforts won't vanish. They'll simply evolve. Instead of focusing on categories, future programs may emphasize universal principles: civility, mentorship, professional growth, and equal treatment for every applicant. In a sense, DEI may transform from a movement centered on identity into one centered on shared humanity. Still, uncertainty hangs in the air. For every company rewriting its policy, another is waiting to see how the first wave of investigations unfolds. For every lawyer advising caution, there's another urging resilience and adaptation. The tension between risk and principle, between following the rules and standing by values, defines this moment in American business. The presidency's new direction has made one thing undeniable. Corporate America is once again at a crossroads, forced to decide how it defines fairness, compliance, and culture in a rapidly changing environment. The story of DEI in the United States isn't ending. It's being rewritten line by line in boardrooms, government offices, and courtrooms across the country. And the outcome will shape not just policies, but the way millions of Americans experience opportunity at work for years to come.